Good afternoon. Welcome to the City of Madeira Beach Code Enforcement Hearing. My name is Bart Valdez, and I'm the appointed special magistrate to hear today's cases. I'm a practicing attorney and have been a member of the Florida Bar for over 20 years. I've been appointed to this position in accordance and with the authority set forth in Chapter 162 Florida statutes. It is my role to fairly and objectively review the matters presented. As such, I would like to advise you of certain matters related to today's proceedings. Today's matters will be heard in the order that they appear on the agenda. Every effort will be made to hear all persons having relevant evidence, argument, or comments to offer relating to the specific case that is being heard. If you wish to speak today, it is necessary that you be sworn in by the city attorney in just a few moments. In all cases, the city has the burden of proof. The city will present its case first. The respondent or property owner then will be given the opportunity to refute the city's allegations. Formal rules of evidence do not apply to this proceeding. However, I will exert every effort to ensure that fundamental fairness is afforded to all parties. After hearing all relevant evidence, I will then issue an order. The order will be reduced to writing, and you will be provided with a copy by mail. Therefore, please make sure that we have your current address. Additionally, you are advised that I do not have the authority to grant you a variance, permit, or special exception of any kind. My role is solely to determine whether a city code has been violated and to provide you a reasonable time to correct the violation by whatever means is available to you. Please be advised that you may be subject to a fine and a lien may be recorded on your property if the violation is not corrected by the compliance deadline. If you wish to present any information to me today, it is necessary that you swear or affirm that you will tell the truth. Therefore, at this time, I'll ask the city attorney swear in all witnesses.
You'd stand up, raise your right hand, be sworn under oath. Swear that testimony you're about to give today is going to be the truth, the whole truth, and nothing but the truth? Okay, thank you.
All right, the first matter on the agenda today is case number 2023.3699 for the property located at 314 129th Avenue. Is the city ready to proceed?
We are.
Go ahead, Mr. Trask.
I would call Grace Mills as our witness today. Grace, if you can explain your occupation and your job responsibilities here at the City of Madeira Beach.
I am code compliance with the City of Madeira Beach. I work with permitting and violations in the building department.
Okay, are you familiar with the property that is located at 314 129th Avenue?
Yes,
Okay. And is this a case that was a proactive case, or was it a result of a complaint that was received?
it was proactive.
This property at 314 129th Avenue East, who is it owned by and how do you know that?
It is owned by Paradox LLC. If you look on beginning on page 3 in the packet, this is the property appraiser's card. And it is reflecting Paradox LLC.
Okay, and did you also check to see what the tax collector provided as the owner?
Yes, I did. That begins on page 6. And it also reflects, let's see. Owner is Paradox LLC.
All right, thank you. So when was your first dealing with this property?
November 1st, 2023 was when the courtesy notice of code violation was sent.
Okay, and did you go out to the property to inspect before you issued this letter dated November 1st?
Our building official did.
Okay, and when the building official went to the property, who is the building official that did that?
Frank DeSantis.
And when he went to the property, what did he find when he arrived at the property?
There were multiple health and life safety violations and concerns of the property falling into disrepair.
Okay, so you had mentioned that you issued a courtesy notice of code violation. If you could, do you have that there then? You have it pulled up on the screen?
Yes.
Okay, and if you could go through that courtesy notice as to the code violations that were being cited, and if you could go through the photographs too and explain the photographs page by page.
Sure. So the first ordinance that we said was 1491, declaration of an unfit structure. Would you like me to read each of them?
You don't,
No.
you do not need to read the content of them. I would just like you to cite the sections.
Sure. 1491, declaration of unfit structure. 1469, same maintenance of exterior premises, and that covered 3 and 8. 1470, same general maintenance, and that covered 2, 3, 4, 6, 7, 9, and 13.
Okay, and you're referring to subsections underneath each one of those code sections?
Yes, that's correct.
Okay, all right. And did you tell the property owner what the property owner needed to do to bring the property into compliance on that?
Yes,
letter?
the corrective action was listed in both letters.
Okay, and that was what?
Either the property owner or a licensed contractor will need to apply for and obtain a building permit to repair violations. If the permit cannot be obtained, the structure must be removed.
And did you give a follow-up date that they needed to come into compliance with that direction?
Yes, November 15th
Okay,
of
2023.
2023. Yes.
Okay, and if you could go through the photographs then that you've got in the packet, starting at
Starting-
page 12?
Yep, starting on page 12 is a photo of the front door where it's a better view on page 13. It's where the unfit for human occupancy was posted. That was posted November 2nd, 2023 on the property. Then following to page 14 is just a general overview of the exterior of the house, I believe from the roadway. 15 is another exterior showing the second level as well. 16 is one of the bottom porches of the house exterior. 17 is a shot showing the disrepair of the soffit fascia on the second story of the property. 18 is an exterior or interior photo of the house. It looks like the flooring. 19 looks like some damage to the wall and or ceiling from the interior. 20 is more damage to the ceiling of the interior of the home. 21 is from the first level of the home, I believe that's either the side yard or the backyard. 22 is actually bees or insects that are in the home from the walls. 23 is showing the electrical panel, it's out of date for the fuse box. 24 is showing the second level porch, and there's actually some holes in there, and just showing the dilapidated porch as well. 25, I believe that is a bedroom on the second story, just showing the interior of the home. And 26 is showing the second story roof from the inside.
Okay, this last photograph, then it's actually, some of the ceiling has been removed from the second floor
That's correct, and you can see the sky.
through the ceiling, through the roof.
Yes.
Okay. All right. Did the property owner contact you or the city after this initial courtesy letter was issued?
Not after the initial first courtesy letter, no.
Okay. So obviously, they were not in compliance on November 15th, correct?
Correct.
All right, and you did then issue a notice of code violation?
Yes, November 15th, 2023, the notice of code violation was sent certified.
And is that reflective in page 27 of the packet?
That's correct.
Okay, and the rest of the pages 28 and 29 are the remainder of the notice, but the photographs that follow it, are these the exact same photographs that you just referenced in the courtesy letter?
That's correct, yes.
Okay. So in this code violation notice that you issued on November 15th, did you have a follow-up date on that you were asking the property owner to bring the property into compliance?
Yes, that was November 29th, 2023.
Did they bring it into compliance by that date?
They did not.
Okay. And what was the next action that the city took when there was no compliance on that date?
We sent out the magistrate letters. Let me scroll all the way down. Goodness.
I'd like you to start on page, I guess, 48.
Okay, that would reflect the statement of violation request for hearing that was sent on July 19th, 2024.
And how was that statement of violation request for hearing sent to the property owner?
Normal mail, certified mail, and it was also posted at the property.
And did you also issue a notice of hearing?
Yes, I did. That would be reflected on page 50 and 51 and 52.
Okay. And then you issued an affidavit of service reflecting the type of service that you provided to make sure that the property owner had these notices?
That's correct. That's starting on page 53. That was sent July 19th,
Okay,
2000.
and that affidavit was executed by you?
Yes.
Okay. So on pages 55 and 56, it looks like there's a certified mail and a green card. Was that for the notice of hearing and the statement of violation?
Yes, those were for the prior documents.
Okay, and have you received the green card back on this last notice?
Yes.
You have received it?
Oh, I'm sorry. No, not for this case.
Okay, but you did post the property and post it at City Hall as well?
Yes, that's correct.
Okay. And does page 57 reflect a photograph of the posting of the property?
Yes.
And does 58 reflect a posting of the notice at City Hall?
Yes.
Okay. Have you had any contact from the property owner during the rest of the process? I asked you after the courtesy letter, but any other time?
Code compliance directly has not.
Okay. Has anyone in city staff heard from them?
I believe that the planning department has.
Okay. And do you know the specifics of as to what was the conversation with the property owner, with the planning department, or do I need to ask Marcy or the building official?
I would deflect to either Marcy or Mr. DeSantis for that.
Okay. Before I go ahead and talk to either one of those, have you gone out to the property and determined whether or not it's in compliance as of today?
As of today, it is not in compliance.
Okay. How much time do you think it will take to bring the property into compliance?
The city would see that 30 days would be sufficient to bring the property into compliance.
And you're presuming then that the property would be demolished, correct?
That's correct.
Okay. And if the property can't be demolished within the 30 days, what is the daily fine that the city is asking the special magistrate to levy in case there's non-compliance?
250 per day.
And what is the reason why you're asking for the $250 per day?
With this being life, health, and safety violations of the entire property becoming dilapidated, we would see that it would fit for that.
Okay. All right. I have no other questions for you. I do have some questions for Marcy, though.
All right. Is there anyone here on behalf of the respondent? Is there anyone here who is representing the property owner, Paradox LLC? Okay, seeing no one, then there will be no cross-examination. I don't have any questions for Ms. Mills. Go ahead and call your next witness, Mr. Trask.
So I'd call Marcy Forbes. Marcy, can you please tell the special magistrate what your occupation is here at the city and your job responsibilities?
I'm the community development engineer and I review plans and permits for the city as well as anything else that comes my way.
Like, are you familiar with this particular case?
Yes, and so much that the property owners have met with the city at least once, possibly, I believe maybe twice. The tone of our conversation was more about what they could do with the property moving forward. They were aware that there were some issues with that, and Mr. DeSantis was in the meeting as well. And so I believe that there was some conversation about confirming the number of units they currently have. So, but mainly ours was talking about the future, what the future could look like for that property when it was demolished.
Okay, so there was specific discussion that they were not interested in rehabbing the property. It was their intent to actually demolish it?
They seem to, if I remember correctly, there may have been some talk about trying to rehab a portion of it for renting out and maybe recognizing the other portion of it wouldn't be usable. And I believe they may own more than one property too, so I don't want to confuse any of the two, but they did know that there was issues on site with this related to this particular structure that needed to be addressed.
When was the last time the planning department or you specifically had any contact with these property owners?
I believe when I looked at it, it was like maybe April of this year that we had some conversation. I'd have to go back and look for sure, Tom.
Okay, all right, thanks. I don't have any other questions for Marcy.
Once again, is there anyone who has arrived on behalf of the respondent or the property owner who would like to cross-examine Ms. Mills?
Ms. Forbes.
I'm sorry, Ms. Forbes. I have no questions for Ms. Forbes myself, and let the record reflect there is no one approaching the podium or even in the audience on behalf of the respondent. Ms. Trask, do you have any more witnesses?
I would just like to ask a few questions of the building official.
All right, and Mr. Trask, I'll go ahead and move into evidence just for the record. Pages 53 through 58 of the agenda package as exhibit number 1.
Thank you. Mr. DeSantis, if you could tell us what your what your occupation is and your job responsibilities here are at the city.
I am the building official for the city of Madeira Beach, and my responsibilities are to oversee the building department and code enforcement.
Are you familiar with this property we're talking about today, 314 129th Avenue?
Yes,
Were you the person that actually went to the property to see it in its current condition?
yes,
Okay. And are you the individual that issued the certificate of non-occupancy on the property?
yes,
Okay. Were you at the meeting with city staff, planning staff relative to repairing this building or demolishing it?
yes.
Okay. Do you have any specific recollection as to what the property owners were going to do with the property in its current state?
No,
Is it your opinion that this structure needs to be demolished?
yes.
Okay, thank you. I have no other questions.
Mr. DeSantis, just a few questions, just for the record. To your knowledge, is there anyone living in this property or at the property at this point in time?
No,
Are all the photographs that are pictured on page 12 of the agenda packet through page 26 of the agenda packet true and accurate representations of the condition of the property as it existed then and as it exists today?
yes,
I take it, Mr. DeSantis, having seen it with your own eyes, do you also believe that the nature of the violation constitutes a threat to health and safety?
yes.
All right. Mr. Trask, feel free to ask anything and follow up to my
No
questions.
follow-up questions, thank you.
All right. Okay, again, I'll give the respondent one opportunity. Is there anyone on behalf of the respondent who wants to come forward and cross-examine Mr. DeSantis? Seeing none, we will move on. Mr. Trask, any other witnesses?
No other witnesses?
Mr. Trask, are you seeking a violation, $250 per day per violation for all 3 violations, or just finding the respondent in a violation of all 3 code provisions and then just $250 a day after 30 days?
The latter,
Okay,
yes.
all right. Anything else, Mr. Trask?
No, sir?
All right. Let the record reflect there are no members of the public here, but I'll go ahead and say, are there any members of the public who want to come forward and provide public comment in regard to this particular violation of this property? All right, seeing none, we'll go ahead and close public comment. Based upon the testimony and the documents and the exhibits of the city, I'm going to go ahead and find that the property is in violation of the 3 city code provisions that were set forth in the notice of violation. Based upon the testimony of the city, I believe that 30 days is a reasonable time period to come into compliance. And thereafter, there'll be a $250 a day fine on this property. All right, let's move on to the next one on the agenda, which is case number 2023.3683 for the property located at 301 Boca Ciega Avenue. Is the city ready to proceed?
Yes, we are, but I just want to bring to your attention that this property came into compliance late Friday afternoon. I found out this morning. The property owner did obtain a building permit for the fence that was at issue in the case, and he has paid for the permit. Therefore, we're not moving forward with this case based upon his compliance as of Friday afternoon.
All right, do you need me to enter any kind of order or anything like that?
I don't believe so, no. Just remove it from the agenda.
All right, we'll let the record reflect that that property was brought into compliance prior to the hearing, therefore it's removed from the agenda. Just to make sure, I see that there was a case 2023.3717 for the property at 14361 Gulf Boulevard. I note on my agenda that says canceled. Is there any business that I need to take up on that particular matter today?
No, that matter was removed from the agenda because of the fact that there was a code notice issue that I wanted to correct before we move forward on that particular case, and that's why it was removed.
All right, great. We'll move on to the first matter for old business, which is case number 2023.3608 for the property located at 572 Johns Pass Avenue. This was a motion, I construed it as a motion for extension of time. This is a situation where I believe it was the owner of the property, respondent of the property, sent an email to my office on July 9th, 2024. I immediately forwarded it to the city and the city attorney asking that it be put on the agenda for today. So Mr. Trask, I'll let you go first as to how the city would like to deal with this, and then if anybody shows up, we'll hear from them as well.
Sure. I did want to let you know that even though there was no one in the audience, this was properly noticed for hearing. The notice went out on the 22nd day of July. The property owner, Mr. Holcomb, did in fact receive the notice of hearing. I've got the green card in hand. I'd like to walk down and hand it to you. Want to let you also know that the property was posted, and an affidavit of service was also in the packet.
All right, great. Thank you for handling the notice. I'll go ahead and just for the record, put in as exhibit number 1, pages 91 through 96, and exhibit number 2 will be the green card that I note is signed by a person who here appears to have the last name of Holcomb. I'll mark that as exhibit number 2.
Right, so just to give you a little bit of background in this case, the special magistrate held a hearing on October 23rd, 2023. The property owner's contractor appeared at that hearing, and he presented on behalf of the property owner. The property owner was cited with 2 different code sections dealing with the requirement of a building permit. The special magistrate entered an order on October 31st, requiring compliance on November 30th. And if it was not in compliance, that a $250 a day fine would be issued for every day thereafter. There was a follow-up special magistrate hearing on May 20th, where the special magistrate considered compliance or non-compliance. At that hearing, non-compliance was found. Since the compliance date on November 30th, 2023, there have been 235 days, approximately 8 months, where the property owner has not brought the property into compliance. As for the ordinance that Mr. Holcomb was referencing, I've got a copy of that I'd like to provide to the special magistrate. This ordinance was discussed numerous times before the city commission. It had its first reading before the commission on May the 8th, and it was adopted on June the 12th. This ordinance does provide for some relief for outdoor kitchens. This is the information that I believe Mr. Holcomb is bringing up in his email to you, that he wanted to address the new code section to see whether or not he could come into compliance. There has been some discussions with city staff relative to that. And Mr. Holcomb mentioned some of that in his email to you as to what he is or is not doing. That being the background, it's the city's position that Mr. Holcomb should not receive an extended compliance date, because we believe that if you extend the compliance date, that he will just have further time in which to delay the actual permitting approval. Even his discussions about something happening in May, we're now in July and it's not been completed as of now. I don't believe that relieving him of the compliance date will be helpful in obtaining compliance. And therefore, it's the city's position that the compliance date should not be revised, that upon Mr. Holcomb bringing the property into compliance, he has other avenues to take relative to the fine, whether it's a fine reduction request or the like. But having taken 8 months and not brought the property into compliance, we think that he should be benefited by having additional time.
Mr. Trask, a couple things here, because he notes in his email that I'm construing as a motion, the $100 a day fine, but I thought I did $250 a day fine. So am I missing, did I enter some different order that I'm not aware of?
So I went back to look at that because I was concerned that there was a different order that may have been entered. I was not able to find a subsequent order.
Okay,
I do have the order that I'd mentioned to you that was issued on October 31st and another one following the May 20th hearing. I'm not really sure where the $100 came from.
yeah, I'm not either. Let me ask you about just a couple of the other paragraphs here. Mr. Trask, in regard to his statement in paragraph 3 that there has been an ordinance change recently that now allows for outdoor kitchens. I've given this ordinance a glance, but I want to understand the city's position on that. Is this a situation where, number one, is he accurately saying what this ordinance says? And number two, is it a situation where, as it relates to the outdoor kitchen, he just needs to call? How would he remedy that? I mean, in other words, how would he be brought into compliance if it says what, the ordinance says what he says it says?
So he'd have to apply for the building permit and get it approved?
Okay, so you still, even under this ordinance, his statement that now, so it's allowed, but you would have to apply for a building permit, in this case, an after-the-fact building permit for his existing outdoor kitchen.
Correct. And I would bring your attention to section 110-491 of the ordinance dealing with outdoor kitchens. And it has some specific requirements in it. So for example, outdoor kitchens must follow the setbacks for open accessory structures provided in this division. We don't know exactly where it's located. We believe that it's in the setbacks and it would not be permitted. It would have to be moved. The countertop structure cannot exceed a height of 36 inches from grade and cannot be larger than 50 square feet in area. They would have to provide us with that information in the permit application. The kitchen must be permanent and meet the requirements of section 94-140. If the outdoor kitchen contains a sink, it must be connected to a sewer line with an inline isolation valve. That would require a permit. Electricity must be isolated with disconnects from the primary structure. That would require a permit. Plumbing lines must have a backflow prevention. That would require a permit. Any sewer and electrical plumbing must be shut off during any named storm event. Obviously, that speaks for itself. But there are a number of, even though outdoor kitchens are allowed under this code section, there are other requirements that have to be met.
And this owner has not met the requirements, has not applied for a building permit, even though he references a contractor. And feel free if you need to reference the city staff on this one, but as we sit here today, he has not applied for a building permit for this, after the fact building permit for this kitchen. So we don't know whether or not, as it's built, it would even apply, this code, he would comply with the new code provision, correct?
I would ask for maybe Marcy or Mr. DeSantis to answer the question relative to exactly where the application is in its process, because there have been discussions. So I would call Ms. Forbes. And you've been listening to the conversation between me and the special magistrate about this issue. Can you enlighten us as to where we are in the application process with Mr. Holcomb on this outdoor kitchen?
Yes, so I have heard from the contractor and the property owner. They were asking for some clarification about the code. This was as recent as last week, and so I provided them that clarification, but they have not circled back around to provide me with anything via email, nor does there appear to be a permit in MGO. I checked this morning.
Well, okay, what was the acronym you used?
Oh,
M-
sorry, MGO, it's our permitting software system,
Okay,
my government.
okay, so we're waiting for information on them and they still have to apply for the building permit in layman's terms. Okay.
Yes.
Okay, and I mean, I think that's consistent with what he's saying here is he's continuing to work. If I'm now looking at the 1, 2, 3, 4, the fifth paragraph, that he's continuing to work with the city officials, which is good. The next one indicates, next paragraph says, it was agreed during the meeting that my contractor would take measurements of the kitchen along with particulars involving electrical and plumbing hookups and provide to Ms. Forbes along with a survey of the property to determine compliance. Ms. Forbes, has he done what he said he was going to do in that particular paragraph?
They have not been able to provide that data yet.
All right. Okay. And we don't know, as we sit here today, whether or not what he has built complies with the new section 110-491. Is that a fair statement?
Correct. Yes, he did allude in his email that there may possibly be some size issues that he may have to address. So he mentioned that, but nothing specific yet.
Sure. And Mr. Trask, I'm going to ask this question to you, but please defer to the city if necessary. There was a third violation in regard to this property and it dealt with fencing around the pool.
That is in compliance.
That is in compliance.
Yes.
Okay. So, Mr. Trask, if I understand the city's position on this, it's that it would not be appropriate for me to grant the motion for an extension at this time because he hasn't applied for a building permit, and we don't know whether or not what he has built there will comply. But what would be more appropriate is after he's in compliance to come back and seek a lien reduction.
That's our position, correct.
All right. Mr. Trask, anything else on this one?
No, thank you.
Okay, I'm gonna deny the motion for extension of time. I'll put in my order, of course, that I reserve jurisdiction to consider a lien reduction once the property is in compliance. Mr. Trask, can you please prepare the proposed order on this one so it says exactly what the
Yes,
city is comfortable with? And
Yes.
especially since this is a brand new ordinance, I want to make sure that my first ruling on this new ordinance is in compliance with the language of the new ordinance as well as the intent behind the ordinance. And let the record reflect that there is no one here on behalf of Mr. Holcomb. And I do go ahead, and you can put this in the order, Mr. Trask. I do find that proper notice was provided to the respondent and an adequate opportunity to appear for today's hearing was provided. All right, so we have one other one. Again, this is case number case number 2022.3526 for the property at 590 Normandy Road. Again, this is a situation where well, I guess not again, but this is a situation where Mr. Tav Vestgarden filed a motion for continuance of hearing on motion for extension of time. I guess, and also filed or sent correspondence asking for some additional time. He filed a motion for an extension of time to comply with magistrate's order. So, Mr. Trask, what's the city's position on this particular matter?
okay, so the way we see this is that there is an order entered. It provides that Mr. Vestgarten needs to comply. He has filed this motion for extension of time to comply again. This is the third one, I think. That was dated July 17th. After he issued this motion for extension of time, which we set for hearing, and he did receive it, and I've got the green card providing for today, showing that he was properly noticed by way of a notice of hearing and service on him by way of posting the property in City Hall. And once that was received, he did file a motion for continuance of a hearing on his motion for extension of time to the August hearing. The city has no objection to having his motion for extension of time to be heard on the next special magistrate hearing. He asked for it to be after August 15th, and my review of the calendar shows that our next meeting here for special magistrate is August 29th, and so that would work. So the city has no objection to having his motion for extension of time heard at that time.
All right, thank you, Mr. Trask. If you can do the same thing on this one, just prepare a proposed order. And I'll go ahead for the record, while you're bringing me the green card, move into the record as exhibit number 1, pages 97 through 112. Exhibit 2 will be the motion for continuance of hearing on motion for an extension of time. And exhibit 3 will be the green card showing that he received notice of today's hearing. So if you can just send me that proposed order Mr. Trask, and then if the city can take whatever steps are necessary to notice that for August 29th,
We will do that.
that'll be fun. Are there any other matters before me today?
Not on the agenda, no.
All right, that will conclude today's hearing. Thank you all very much.
Thank you.